quickly about myself. I'm not a lawyer. I'm a GDPR analyst, and my background is in academia. I was a jurisprudence scholar, so my it was researching legal reasonings, how lawyers think, how judges think, how legislators think, and how regulators think. So legal reasoning is not one monolith, there's different varieties. And some legal reasoning is good, and other is BS. So you have to be able to call fallacies in legal reasoning, and that helps the legal profession. So it's not, as you can imagine, a type of professional profiles that lawyers love very much, because you're always going over the arguments with a red pen. But I'm not offering legal advice. What I'm offering is a combination of this legal reasoning with business advice, because I left academia 10 years ago, and I moved to the city and started running businesses during the recession, which was a lot of fun. But it gives you a sense of what needs to happen for a business to come together and push through a sort of in crisis mode. And the GDPR has come to the stage where we're now in crisis mode. So I think knowing what you need to do in a business when you're in crisis mode, plus knowing how legal reasoning works, is a good enough mix. And possibly, I'm going to tell you something that you've not heard before, or that you've not heard the way I'm going to say it before. Hopefully it's something new for you. Okay, I'm focusing on 5 things, because I think they're the tricky ones, and the ones where I, as an analyst, tend to disagree most with the bog standard middle of the road legal advice. So if you are going to hear stuff from me that your lawyers disagree with, good, it means that we've got a success. But there is a certain difference in how businesses need to look at the same legal issue. One of the quickest way to explain it is when somebody says you need to find a law firm that has the same risk appetite as you as a business. This is total nonsense. A law firm's risk appetite is diametrically opposite to a business risk appetite. Litigation for them is revenue stream. For you, it's revenue drain. So this slight antithetical approach to the law cannot be brushed under the carpet. So it is your prerogative as a business or as public sector to choose the legal advice that suits your case. You really have to be careful and buy legal services just like we buy any other service. So I'm going to finish my rant here, but there is no equivalent to assessing legal service on a total cost of ownership basis. You know, okay, what if the legal advice you give me happens to be overruled, and now I have to redo all my IT architecture? Because how does that come into your view? So there is a certain amount of discretion you have in choosing what legal advice or how to ask for legal advice. So there's tactical legal advice that will give you what I call minimum viable compliance, and then there's strategic long-term sustainable legal advice that gives you maximum regulatory load tolerance. It's obviously an ambition to be able to withstand the maximum scrutiny of the regulator, but it's up to you to choose which one you want. And obviously, if you go for minimum viable compliance, I advise that you have large litigation budgets, and that has to come into the cost of the products. End of story. I mean, money to litigate has to be set aside. So I'm a big fan of saying, is that your legal choice? Good. This is what it will cost on the IT infrastructure, and you'll also have to set aside litigation funds for it. So my very first question when I approach one of these vendors is, what do you mean? Have you done your homework? Can you tease out the differences between PII and GDPR personal data? Mostly they haven't, and they use the 2 terms interchangeably. So that's one of the areas I always zoom in, and I recommend that you do the same with vendors when you vet them, when you have a beauty parade. So just very quickly, personal data in European data protection, and especially with the GDPR, obviously direct identifiers, / insurance number, indirect identifiers, things that can link to you on a probabilistic basis. So your home address is an indirect identifier. The other thing to look out for, and this is a little bit new for the UK, because traditionally the ICO did not see eye to eye with the rest of Europe, but now they'll have to align. And this sort of novelty is that you have to look at personal data also as you have to name, you have to identify as personal data. Also, information that has the potential to identify somebody uniquely when cross-referenced with other information, yeah, that is out there in the wild. Let that sink in. Not information that you have, not cross-reference one data set that you're in control of with another data set that you're a controller for. No. Data set that you're a controller for, cross-reference with data sets in the wild, could identify some electoral roll. It's the most obvious thing. But in any way, what this means is that to know what personal data you have means having some sort of control over what you have and also have some sort of monitoring of what's out there. What's available for sale, what's open data, call it what you want. But anyway, this potential to identify, so that's also personal data. The jurisprudence is now slowly accepting that metadata is personal data. If metadata, system-generated data, call it what you want, it has the potential to identify an individual, well then that's personal data. So you have to treat it with the GDPR rules, with the data protection rules. Structured, unstructured, semi-structured, it's all personal data. So don't forget manually filed data, so leverage folders, filing cabinets. Don't think of digital data only. If there is a criterion, a system of filing it, then that comes under the GDPR rules. And a lot of fines, in fact, have been issued on misplaced filing cabinets when one office moved, office left their old systems file. Okay, I'll give you a few sort of flashes of what counts as personal data so that it really cements, it really sinks in. Think of an opinion, something that has been written about John Smith, yeah? Something written by a colleague of John Smith on an email or something. It's a comment about John Smith, yeah? That's personal data about John Smith. That's John Smith's personal data. Whether that's true or false, libelous or not, doesn't matter. It's his personal data. It's personal data about him, so you have to give it the GDPR treatment. Think of a medical prescription. Personal data for whom? For the patient. Fair enough, but it's also personal data of the doctor. For the patient, it's sensitive medical personal data. For the doctor, it isn't sensitive, it's just professional, but it's still personal data. So, for example, this is a typical example of when you have a document that contains personal data of multiple data subjects. And that's where the headache starts. You think of masking one, but you forget to mask the others. So, you mask the patient, it's anonymous data for the patient, but the document is not anonymous vis-a-vis the doctor. Okay, so this is a case of a document with mixed personal data of multiple data subjects. A child's drawing, for example, you have family sort of crisis and the child has to talk to a psychotherapist. This is an actual thing that came up for the connection supervisory authorities. A child's drawing depicting family relations or family stuff is personal data of mom and dad. So they have a right to see it, for example. Okay, so digital up to a point. Retinal scans. You go for an eye test and you're offered a free retinal scan because, of course, it's a way of checking for diabetes, glaucoma, etc. Fair enough, but that is a unique identifier. It's a biometric identifier. In fact, it's a very reliable biometric identifier. But you don't get told that when you get the retinal scan, but you need to know that that is one of the biometric data. Okay, so this is a vast gamut, and 99% of the vendors I speak to do not make a distinction between PII and personal data. There's a few categories that stand out, and you have to be mindful because they require a separate treatment. One, of course, is children's data. You need parental consent for handling it. Article 9, so-called Article 9 data, which is normally called sensitive, but anyway, it's a gamut of race, ethnicity, sexual orientation, etc. And Article 9 data is also stands out because you need to treat it only on the basis of consent. We'll come back to the basis on which you can handle data, but that's one of the reasons. Article 10 is also sensitive data. You need to remember Article 10 data is anything to do with criminal records, law enforcement, etc. Okay. Identifiability is the killer. That is the really difficult thing to start monitoring and throw resources at. How much will it be enforced? I think the ICO will be quite tough in showing, demonstrating that it's aligned with the rest of that matter. Okay, the second point I wanted to touch upon is what is the essence? What does the GDPR boil down to? What are the GDPR rules for treating personal data? The first thing I would highlight is that it's the GDPR treatment for data is actually GDPR treatment of data flows. There's a tendency to forget that you need to chase data as it moves around. I know you're not that naive, but I want to highlight it because there's a lot of concern about data and storage, but in fact you have to look at the flows or how it flows. It should flow in one direction, but also in the other direction, and I'll come to that. So the focus of data protection is protecting data flows. Make sure that these data flows happen according to the right rules. Between individuals, if this is outside a purely personal situation, so you can have two individuals. One could be the control of the other person's data. Between individual and organizations, of course, data flowing in that relationship, and among organizations. So data flows. The GDPR rules are not just a set of vague principles, but they're very concretely specified in rights that the individual has, and you have mirroring obligations to facilitate those rights. So they're not just abstract rights. For every right that a person has, there's a corresponding obligation that you have to let them exercise that right, yeah, and enable them to actually. Okay, I'll come to some very concrete examples. A quick revision of the 10 GDPR principles, is that useful? Can we elicit them from the group? Just throw them at me, I'll catch them. The ones that are not relevant, I'll discard. One, give me one. Okay, that comes under the principle of, integrity, confidentiality, yeah. If I said legality, does that mean anything to you? Legality, essentially data is like, I kind of think of ivory or blood diamonds. Are they legal? Do you have this data legally or illegally? That's as simple as that, you know. Are you trading data illegally? If you are, you should delete it, stop immediately. So you have to prove that you have provenance, that you have a legal basis. Legal speak is a lawful basis for processing that data. So are you handling that data legally? You have only 6 bases. You can only claim 6 lawful bases. 6 are the reasons why you have this data. And they're worth remembering because they play a very important role on what hits you later on the architecture. Incredibly important. And I cannot emphasize enough, they sound legal, they sound like the kind of stuff that only lawyers deal with, but they impact on your architecture like nothing else. So I'm going to stop here and make sure that you remember. So you're handling personal data legally only if one of these 6 applies. At least one of these, you can accumulate them, but at least one. Contract. So the data you have is strictly necessary for the performance of a contract you're entering into the person. Consent. Vital interest of the data subject. Public interest. There's a European or a UK law that allows you to handle, or legitimate business interest. The key sort of, the crunch of the matter is played out essentially between these 3: contract, consent, and legitimate interest. When can you claim that it's your legitimate business interest? It's a very, very specific, narrowly defined legal term. Don't be fooled by the conversational sound of it. It's not whatever makes the business money. It's a specific definition of legitimate business interest, which we are, by the way, still expecting. So keep it as a placeholder for something to come. But the reason they play they play a massive impact on the architecture is that whatever legal basis you claim for handling your data, it triggers automatic rights on the data subject. And this is where all the sort of chess game between law firms and businesses is being played out at the moment. How do you justify holding that data? Because the justification determines what an individual, a data subject, can ask you to do. Okay, and they sort of behave in an interlocking manner. One legal basis gives the individual a couple of rights, but not the others, and another legal basis does the opposite. So in many ways you have to choose, and you have to choose on the basis of what the business needs, but also I recommend that it's a choice made with IT in the room. It's a choice that has to be costed and has to be worked out as to feasibility. Okay, can I quickly explain you how they work? Or do you know this kind of interlocking situation already? Okay, consent and contract give the individual the automatic right to ask for erasure, right to be forgotten, and portability. And of course, consent can always be withdrawn. Yeah, so consent withdrawal, erasure, and right to be forgotten. What they don't give you, these lawful bases, don't give the individual the right to ask for restriction of processing. Essentially, the individual cannot put their hand up and say, stop using my data now. That is restriction of processing. They don't have that right, but they can ask for the data to be ported to another business, or they can ask to have the data deleted in your records. Legitimate business interest, vice versa, does not give the individual an automatic right to have data erasure or data portability, but it gives the individual an automatic right to say, I'm objecting to you processing my data. Pause. There's a standard legal advice that's been given for firms throughout the city and everywhere. Don't go for consent. Is a rod for your own back. Go for legitimate interest. It's easier. It's easier on the IT architecture. It's easier to defend. Let me tell you it's not. Let me disappoint you. It's not easy from a legal point of view, and I'm sure you'll confirm that it's not easier on an IT architecture point of view to put in place a restriction of processing. Because if somebody says, I object to you using my data, what you have to do is quarantine all the data, stop all the data immediately, and wait for a resolution of the matter. The matter is whether the rights of the individual can be legitimately overridden by the rights and the interests of the business. So essentially it becomes a legal question that has to be determined in whichever way it is determined. Arbitration, you go to court, we don't know how that's going to play out. But essentially, one legal choice means that the individual has a right to ask you to stop processing their data. You have to put in place a hold and wait until you have authorization from the legal side of things to say, yes, we've resolved the matter, you can continue processing that data. If you need to do anything else to that data, other than storing it pure and simple, if you need to move it, if you need to do anything else, you need consent again. So there's consent coming back from the window. You kicked it out of the door and it comes back from the window. So once you have a legal basis, such as legitimate interest, you have to have in place a system of, I call it data quarantine, I don't have another word. The legal term is restriction of processing. But it's very granular, it's very individual. Imagine carrying on doing whatever you were doing, but John Smith is out. You pull him out. Pull him out of your algorithm, pull him out of your retargeting, whatever you were doing, just pull him out. So, and make a mental note make a note in the system that he can come in once the matter is resolved. So they behave in very different ways. Consent is considered the harder, from the legal profession, is considered the legal basis as harder in the business because you have the risk that the person withdraws consent, and you have the risk that they ask you to erase the data or port it to a competitor. So there's a tendency to safeguard the data as an asset and put protections around it by saying, don't use consent. The whole point of a book, the whole point of my talks is that it depends. It depends what matters to you most It depends what your IT architecture can take. It depends what the business use of the data is, because sometimes you're prepared to sacrifice operational expediency. You prefer to put in place all these quarantines because you want to hold on to the data. It generally is an asset that you're monetizing in a way that is non-negotiable. If you're in insurance and you do profiling, you have accumulated data, you have this very complex sort of sets of data sets. Presumably, you are prepared to put up with the restriction processing risk in order to hold on to what you've created. But again, maybe not. But I recommend that you're in the room when that decision is made. Don't let it be a legal decision only. It never is just a legal decision. It really never is. Okay, but legality. So the whole principle of legality sounds abstract, but it hits you so hard and so centrally that you should not underestimate it. So legality, you need to have a basis for holding data, which is a nightmare. Nobody, I think, has a correct lineage of reasons why we're collecting data sets. And then you can go wholesale. You can say our whole data is on contract basis, or it can be very, very granular. You know, our HR data is on contract basis. We have an employment contract. Our customer data is on direct marketing purposes, so that could be legitimate interest. And that is also a decision that you should not leave to the lawyers. You should be in the room where that decision is made. I don't know how your data sets are organized, but each lawful basis has an impact on what could happen to that data down the line. So only you know how your data is organized and what would make sense, not just from a business perspective, but from your technical perspective. So I recommend that this legal basis you sort out as soon as possible. Transparency is the other key issue, the other key principle. So regarding transparency, transparency is essentially tell them what you're doing with the data, because the individual continues to have a right over the personal data, even if it's in your system. They continue to have a right over it. And it's the right to be informed as to what's happening and the right to have action taken, like erasure, etc. So the right to know what's happening to the data breaks down in 7 rights. And I'll need 7 volunteers who undertake to remember them, because we'll come back later on. We'll have an example. Okay, the first one is they need to know, and you need to tell them what data, what personal data you hold about them. Yeah? What categories, how much of it, you need to say. Who's going to remember this, please? One volunteer. Okay, right. What data you hold. The second item of information you need to tell them is what's the purpose you're holding that data for. Purpose. Okay, what data you hold, purpose. The third is what's the legal basis. Remember the legal basis. If you use a legitimate interest as a legal basis, you can't keep it to yourself. You have to declare the legitimate interest. Yeah? So who's going to remember legitimate interest? Volunteer. Thank you very much. So you have to declare what your legitimate business interest is. You have to declare who are the recipients. Who is their personal data going to? Very specifically. You can't just say third parties, associates. You have to name them. The individual needs to know who their data is going to. So recipients. Thank you. Time frame. They need to know how long you're going to have it for. Time frame. Time frame. Okay. Whether profiling is taking place or not. We're profiling you. By the way, we're profiling you. Can we have your data? So that you have to say up front. So these 7 items of information, you need to tell the individual before you start using the data, at the moment of collection, if you're collecting it from them directly. If you're collecting personal data from third parties, you need to tell them as soon as possible, at the latest within 1 month, and in any event, before you pass on their data to somebody else. Okay, so you really need to tell them what you're doing with your data. That's transparency. Okay? Now, one word about data provided by the data subject. There's been clarification from the authorities, previously commissioners, that this can include metadata. Essentially, the interaction of an individual with a device, with an operating system, is data provided by the data subject. So don't think that provided by the data subject is only data entered manually in a form or actively expressing event. It's also data observed, so metadata. Okay, so you have the obligation to tell them these 7 things when you collect data, when it's from them, directly from them, before you start using it, and as soon as possible if you get it from third parties. Fairness is the 3rd principle, and then I'll stop because I'm going to move on. Fairness essentially is give them a chance. Give them a chance to rectify it, give them a chance to delete it if they don't want you to have the data, give them a chance to take it somewhere else, portability, we've seen it before, give them a chance to object to processing. They may have given you, okay, fine, consent. You need to tell them that you're profiling or that you're processing. So the presumption there from the legislator is if they've given you consent, you can go ahead unhindered. They can't object no more. They cannot object anymore. But if you're using legitimate interest, then have the right to object to you using on the basis of legitimate interest. And restriction processing. Okay. So fairness is to have a chance to do something to that data that you have about them in your systems, and you have the obligation to facilitate that. For each right, there's a mirroring obligation. There's other 7 rights, very quickly, that you may be familiar with. Integrity, confidentiality, and accuracy, the cardinal in data security in general, so nothing new there. Accountability is the last principle, meaning for every one of these actions you take, prove to the regulator and to the individual that you have taken it. Demonstrate it, you know? Okay, facilitating all these rights, okay, prove it, show it. So you need to have a lot of accountability. Okay, we come to the controller-processor situation, which we have lots of questions about. How are we doing with time?
Good.
You're good, okay. You don't always have the same level of responsibility towards personal data. You can have a controller level of responsibility, which is the highest. For example, you have a 72-hour notification obligation if there's a data breach, if you're a controller. But you may just be a pure processor. I'm sure you know the distinction, but I'll repeat it very quickly. The controller decides the how and the why of data processing, the types of data, and the type and the categories of people it ends up with. So the categories of recipients. So the how, the why, categories of data, and categories of recipients. This is the data controller. The data processor decides none of that, just handles, processes data on behalf of the controller, strictly to instructions. No creativity, no improvisation. Yeah, you stick to the contract. If you do behave as a pure processor, you have a lower level of responsibility. You still have to apply principles, but as I said, you do not have the data protection impedecessor obligation. You have an obligation to help the controller with the DPA. You have the obligation to assist them with the data breach, but it's not you that has to go to the ICO and declare a data breach. So knowing what you are vis-a-vis the data, and the controller processor matters. It triggers different obligations. And it's always important to remember it's not a contractual decision. It's not something that the lawyers decide and it stays as is. It's a factual determination. Essentially, no matter what the contract says, if you start behaving as a controller, even if the contract says that you're a processor, the ICO and the regulator will treat you as a controller. You'll be fined as a controller. That's called becoming a joint controller. So it's important that everybody in the business knows that being sort of undertaking to do business with data brings the whole organization into different territory. So that's one of the things that training should really push, you know. Obviously, data deals involve, business deals involve data. Business deals are essentially data deals, and I don't know how decentralized, you know, businesses are in your situation, but in a very federated business where there's a lot of business autonomy, business units, people are creatively going into joint ventures, partnerships, you can put the whole organization in a position of becoming a joint controller for data. But if the individual doesn't know that, he's stiffed. So that's one of the key issues to teach everybody. And also remember that even if you're a pure processor, some functions remain controllers. So your HR function will always be a controller of its employee data. If you have one unit that does membership organizations are always controllers. There's always a legal presumption they're controllers of their members' data. So this variation of what you are, what obligations you have towards the data, according to what you do with the data, is absolutely key. And this is one of the things that's hardest to code into the stack, is obviously one of the things that has to be process and training. But obviously, if you can flag this up in any form in the system, that would be a huge help for the individuals concerned. Okay. The definition of processing is also probably worth pushing around the organization a lot, because I'm not sure that people understand that any time you touch the data, you're processing the data. Would you say that's a done thing? Shall I give you the list of what processing means? No, you know it? Okay. Consulting is processing. Disclosing is processing. Disseminating is processing. Combining is processing. Aligning is processing. Okay, there's a list. You can check it up, call me, but it's anything you do to data is processing. Okay, now the dependencies we discussed, and this is the key reason why you need to be in the room from the start on this journey, even if the lawyers push you out, because and this is why I called it a 3-variable equation, because the business reason for using that data determines the legal choices, and the legal choices determine what happens to your architecture. So it's variable 1, variable 2, and variable 2. So in many ways, you come at the end as IT in many ways, but you're also the first ones to see the dependencies. I speak to no other professional profile that has to work out from the start how it's all slots together. And it's enterprise architecture. If you use that framework, or if you do microservices, it's a nightmare. But essentially, the dependencies need to be clear to the IT leaders from the start. If they can be sort of coded, or if they can be somehow embedded in the stack, good. If they can't, they need to become a process thing. But that's essentially the reason why you need to be there. So the modeling the equation is in many ways IT, the CIO, the IT leader's job. Modeling the equation, understanding that business deals drive data flows, and data flows drive legal choices, which drive IT. We've discussed consent and legitimate interest. I don't want to go over it again, but the other ones that could tip the balance, of course, are children's data. If you've never handled children and you suddenly start handling children's data, you have to have the consent, the parental consent, so a mechanism to verify parental consent. If you start handling sensitive Article 9 or Article 10 data, you have to remember that that can only be handled on a consent basis. You can never, in no circumstance, use legitimate interest or contract. So that is really a consent, so you have to have a way of monitoring consent and allowing what consent allows. So withdrawal, erasure, and the other dependency that you should really be careful is where does the business source its data? Is it all sourced internally? Is it all data that we produce as an organization? Do we buy in? Do we buy it from third parties? Are we buying in lists? The obligations to inform and the obligations to take action are different in the two cases in terms of times. The controller status, processor status. Erasure, in theory, should be connected to the business goal for having data. In theory, your deletion schedule should be connected to the business purpose for having that data. In practice, it never happens. That's sort of timed, etc. But that's also one of the things we should discuss from the start. Purpose is also interesting for you, because every time the purpose changes, in theory, you should go back to the individual and say, we're repurposing the data. Are you still okay with it? You have to make the determination, but you have to have that lineage, that sort of thread between the data and the individual that's never really broken. You should always have a way of going back to the individual, so we're doing something else with the data. Okay, last, and then we'll open the floor. I promised that I'd give a fictional example of an ecosystem, because the GDPR really is not, you can't fly solo in GDPR, it's a value chain, everybody needs to come with you. But the reason that the way it works, and the way it works in a very prescriptive manner, even if you are a pure processor business, if you're pure contracting, that all you do is take instructions from clients, is Article 28. I call it the value chain integrity article. That's not a legal term, but essentially it's a very clever article that makes sure that there's a double lock between what the controller and the processor do to each other. I'll break it down in 5 key rules, and then I'll stop, and you'll see why it's a big value chain thing. The controller has the obligation to only do business with processors, contractors, that are GDPR compliant. In business terms, that means you need to check GDPR compliance before you start doing business. And in practical terms, if you're a processor, it means that you have to flag out your GDPR credentials very visibly and very quickly, because it will start coming down in tenders, requests for further particulars. If you haven't seen it yet, you'll see it very quickly. The other legal rule is the processor, so the contractor, must have prior written authorization by the controller before touching the data, before engaging another processor. So, plain English, tell your client that you want to subcontract and get their authorization. So you can't subcontract off the bat without authorization from the client. So they need to know that you're subcontracting. The third rule is that the processor must process data only if the controller, the client, sets out subject matter, duration, purpose, data types, and obligations. What that means is that in practice you can't just take a phone call and enter into a verbal contract, says, okay, we'll sort it. It has to be written, it has to be specific as to subject matter, time, purpose, data types, and obligations that you have. So get it in writing. Business rule, you can't just create it and extemporize if you're taking a contract. Okay, almost there. As where the double lock comes in. Suppose a client, a controller tells you, please, these are my instructions, handle the data as I'm telling you, and you realize that that infringes the GDPR. You can't say, I'm only following client's instructions. You have a legal obligation to not follow, to not go against the GDPR, plus an obligation to flag out to the controller that their instructions are against the GDPR. Lock, obligation to find only GDPR contractors lock the other side, in the other direction. Only do business that is GDPR compliant and tell controllers that their instructions are non-GDPR compliant. So the only following orders line is not going to cut it. And lastly, and that's the beauty if you like this kind of things, every time you engage a subcontractor, you have to impose on them the same obligations that the client imposed on you. So you carry on the value chain integrity. Whatever obligations you have, you impose on your subcontractor and they will have to impose them on you. But you never shake off liability. As your first contractor, as your first processor, you remain liable for whatever they end up doing. So you can tell that you have very strong interest in verifying that they're GDPR compliant as well.